Ripple XRP has won another important victory over the SEC. When do you think the final decision of the court will be announced? How many more victories do you need to convince the court? We will answer all these questions in today's video. Case developments concerning XRP. Another victory has been achieved by Ripple Labs in its ongoing legal struggle against the U.S. Securities and Exchange Commission. SEC new court judgment shows that Judge Annalisa Torres rejected a SEC's request to keep the notorious Ponzi scheme under wraps. The U.S. SEC has asked the court to keep the Hinman speech documents under secrecy because they include internal agency discussions. But the court rejected the SEC's challenge to Judge Sarah Netburn's decision. SEC's claims that the records related to the notorious Hinman speech were protected by the deliberative process or attorney. Client privileges were thrown out by Judge Netburn. The Commission, however, has argued that sensitive materials should be kept under wraps since they have no bearing on the pending summary judgment motions. According to the judgment, the court does not agree with the U.S. SEC and considers the Hinman speech memoranda to be judicial records that should be open to the public. The court finds the contentious papers to be relevant to the exercise of the judicial function and potentially helpful to the judicial process. The defendant in the XRP litigation, Brad Garlinghouse, has shared his thoughts on the recent victory against the U.S. SEC. He called it another victory for openness. He also said the public would soon have access to all of Hinman's emails and records. Even the Commission's claim that secrecy is necessary to maintain openness and candor was shot down by the court. U.S. District Judge Annalisa Torres has added a new wrinkle to the current Ripple vs. SEC's court battle by rejecting the SEC's request to conceal papers relating to the Hinman speech. This new development follows a lengthy court order from last year, when Judge Sarah Netburn demanded the regulatory body hand up the documents to Ripple as part of the discovery procedure. On December 22, 2018, the SEC filed a move to seal texts, expert reports, and internal emails relating to Hinman's comments, arguing that the public's right to access documents of irrelevance outweighed the agency's goal. Meanwhile, Judge Torres indicated that Hinman's paperwork may play a role in the court's decision. The files in issue include correspondence and remarks made by William Hinman, a former director of the Corporation Finance Division at the SEC. The former official denied that Ether was a security back in 2018. The files also include some first thoughts and research for XRP. Because they provide the SEC's first impression of XRP, the papers are crucial to Ripple's argument. Following a recent court ruling, the securities watchdog was given permission to redact the personal information of persons mentioned in papers filed by Hinman. Torres also gave her stamp of approval to certain deletions suggested by Ripple. The judge, however, ruled against certain redactions that included XRP. Judge Annalisa Torres denied the SEC's attempt to seal the disputed Hinman papers, allowing Ripple to postpone their release until June 13. According to a court order, the documents, which include former SEC Division Director William Hinman's 2018 summit speech declaring Ethereum, ETH, and Bitcoin, BCE not securities, were expected to be released on June 6. The court order on September 9, 2022 specified that both parties had precisely 21 days following the sealing judgment to produce public redacted summary judgment materials. Since the judge ruled on May 16, Defense Counsel James Key. Filan anticipated these discoveries on June 6. On May 19, Filan tweeted that Ripple and the securities regulator requested a one-week extension until June 13, 2020. To file public, redacted versions of cross motions for summary judgments and accompanying exhibits, which includes the Hinman materials. As he later confirmed, the judge approved this request, which the parties filed in light of the voluminous nature of the materials and redactions. As was the case with the previous expert testimony motions, called Dobert motions, which were significantly less voluminous, the letter states. According to pro-Ripple lawyer John Deaton, the Hinman email release will include Brett Redfern, SEC Director of the Division of Trading and Markets, who told Hinman's that this speech is going to lead to more market confusion, as Deaton told Fox Business journalist Elir Terret on May 21. Ripple's chief legal officer Stuart Alderoty previously cited a U.S. Supreme Court opinion that legal teams and courts should adapt factors from old cases to fit the evolving legal landscape. suggesting that the Howey test should be interpreted within the common law framework. Last week, he cited a 1976 Supreme Court ruling in which the SEC ruled that art lithographs offered for investment were not securities if the vendor had no post-sale contractual commitments to the buyer. Reasonable grounds to conclude that XRP does not satisfy all elements of the Howey analysis and is therefore not a security for purposes of the federal securities laws, the email states. The SEC's case against Ripple hinges on XRP and other cryptocurrencies meeting the Howey test's definition of securities. Thus, any SEC official or internal document stating that XRP is not a security might be fatal to its argument. Deaton added that the SEC's representative may have been quoting another XRP study. Pro-crypto lawyer Bill Morgan believed in SEC attorney sent the message. Morgan added, most likely in SEC attorney, given how many were involved and commented on Hyman's speech expressing his personal opinion. Many expect the SEC to disclose Hyman emails to clarify these suspicions. Ripple has made many platform growth-focused announcements in the previous week. Ripple acquired Medico for $250 million. Focus on growth opportunities outside the U.S. was the company's CEO Brad Garlinghouse's explanation for the acquisition. The crypto payment business said its C-BUDC platform works with the XRP ledger and token. Based on a prior court order, defense attorney and former federal prosecutor James K. Filan anticipates the release of the controversial Hyman speech materials on June 6. Bill Hyman, a former director of the SEC's corporate finance section, made statements in 2018 suggesting that ETH, was not a security, and these statements are the subject of the Hyman paper. The records include internal SEC debate and discussion over the speech in question. Filan, who has been keeping a close eye on the SEC's EVs, Ripple case for the last 2 years, updated his followers on May 17 about the possibility of unsealing the papers. In accordance with the court's order on September 12, 2022, the parties have 21 days to submit publicly available redacted copies of the summary judgment papers in accordance with the sealing judgment papers From the date of the judgment yesterday until June 6 is 21 days. However, if the SEC files an appeal or if a settlement is reached, the stated schedule may be altered, according to some observers. Jeremy Hogan, partner at Hogan and another attorney watching the case, said the SEC has about 10 days to submit an appeal to this particular judgment. Some members of the XRP community, like Ashley Prosperone, think that the possibility of unsealing the papers might encourage both parties to negotiate a settlement, as they each could be sitting on material that they don't want the other to have access to. Ripple CEO Brad Garlinghouse said on Twitter on May 16 that the company is eager for the unredacted Hyman emails to be publicly available soon. Ripple Labs has had access to the records for some time, but it still considers this part of the case to be crucial in refuting the SEC's claims that XRP is a security. Towards the end of December, the SEC filed a request to seal the records from public view, citing no relevance to the result of the case and the SEC's purpose outweighing the public's right to see the documents as reasons for doing so. The request was formally refused on May 16, giving Ripple Labs a victory this week.